Right, it looks like that's starting to settle down. Right, so hello everybody. Thank you very much for joining this Friday afternoon seminar on Zambrano carers. My name is Nicole Masri. I'm an immigration solicitor at the charity Rights of Women, and I'm going to be chairing this afternoon seminar. Before I give a little bit of a brief introduction, I'm just going to address the housekeeping issues for this afternoon. So hopefully you're aware that live auto transcription is enabled for this event. You'll also note that it's being recorded, and you'll see that we're in a webinar format, which means all your cameras and microphones are turned off, so you don't need to worry about yourselves being recorded. It will just be those on the panel. There is a question and answers function at the bottom of your screen. In order for you to write down questions that you have for the panelists. There will be time for questions and discussion at the end of the presentations, so you can put questions to the panel members. It's probably worth having a look always at previous questions that have been typed in, because if someone else has already posed the question that you have, there's a function where you can upvote it so that it can be prioritised by the chair. You can post questions at any point throughout the session, but of course we'll only be looking at them and addressing them at the end. I'd say try to avoid using the chat function in order to raise questions, because that's not where we'll be looking for the questions, but of course do feel free to use the chat to discuss issues between each other and share any experiences more generally. Right, so by way of introduction, for those that don't know me or Rights of Women particularly well, Rights of Women has quite extensive experience of the EU settlement scheme. We've been engaged in influencing work around this area since 2018, when the scheme, even before the scheme was launched, in fact, and we've been providing advice and assistance to vulnerable migrant women, predominantly those affected by violence against women and girls, since the second private testing phase of the scheme in November 2018. We at Rights of Women are particularly concerned about this particular cohort, that is of Zambrano carers, because in our experience they are predominantly women who are sole carers of young children, and in our experience many have been subjected to domestic abuse from their former partners, and many experience considerable financial hardship due to a variety of factors, but including their sole caring responsibilities, their ineligibility for benefits if they are relying on the Zambrano route exclusively, and if they also rely on the FM route, of course, the burden of paying to maintain their immigration status in the UK. Just to make sure that we all have a bit of a shared understanding, when we're talking about Zambrano carers, we are of course talking about the non-European carers, primary carers of a British citizen, usually a child, in circumstances where that British child would be unable to live in the UK or another EU country if their primary carer was required to leave the UK. Now, in quite an unexpected concession, we all now know that the government decided to include Zambrano carers under the EU settlement scheme and offer them a free route to settlement in the UK. But despite agreeing to include Zambrano carers under the EU settlement scheme when that route was introduced in May 2019, government changed its approach to Zambrano carers at that time. The Home Office suddenly declared, through its rules and its guidance, a new policy, that is, that there could be no Zambrano right of residence at any time that a person had limited leave under domestic law already, and there could be no Zambrano right of residence at any time when a person didn't have limited leave under domestic law already, but could have applied for it. Now, the consequence of that change in rules and policy was that it effectively excluded most Zambrano carers from the EU settlement scheme entirely. Now, that's the context in which Ms. Akinsanya made her EU settlement scheme application. So she was and is a Nigerian national who was the sole carer of a British citizen child, and she had in the past been granted a derivative residence card as a Zambrano carer. But like many who had those derivative residence cards, she needed access to public funds. And so she followed Home Office advice and made an application for limited leave under Appendix FM and was granted limited leave as the parent of a British child under the rules. And that was her immigration status when she made her application under the EU settlement scheme back in 2020. So when she made her application, she had limited leave. And of course, that was the basis on which the Home Office refused her application under the EU settlement scheme. And when she received her refusal, she brought a legal challenge to the rules of the EU settlement scheme, Zambrano route, which started in the High Court and then moved up to the Court of Appeal. Now, the first in this seminar series that took place back in March, the beginning of March, took us in quite a bit of detail through that January Court of Appeal judgment. And Simon will touch on it again today. But the main issue in the case before the Court of Appeal was whether the Home Office had got the law wrong when they wrote the rules of the EU settlement scheme Zambrano route to exclude people who had limited leave on another basis. So the two key issues that were argued out in the Court of Appeal were firstly, whether the Home Office got the European law wrong. So that is, did they misunderstand the scope of the Zambrano right to reside in EU law? And secondly, whether the Home Office got the UK domestic law wrong. So did they misunderstand their own UK regulations, what they said about the scope of the Zambrano right to reside? Now, in January this year, the Court of Appeal decided that the Home Office were essentially right about the extent of the Zambrano right to reside under European law. So the court said under European law that a person can't have a Zambrano right to reside at any time. They also have limited leave, but as soon as that limited leave ends, the Zambrano right kicks in. And that's going to be sort of a really important principle, and it's one that the Home Office has chosen to implement, and Simon's going to talk to us a little bit more in detail about how the Home Office has chosen to implement that principle. In Ms. Akinsanya's favour, the court did find that while the Home Office was right about the European law, they were wrong about the meaning of the UK regulations, which had been written in such a way as to be more generous than European law required. Now, because of the court's finding that the Home Office had got that UK domestic law wrong, the Home Office had to go away and reconsider the EUSS Zambrano route in light of the court's findings. And at that time, the consideration of all EUSS Zambrano applications were placed on hold while the Home Office undertook that review. So our speakers today are going to talk about the outcome of that review and what happens next with the litigation that is ongoing. Right, so I'm going to hand over to the panel now, and I have the pleasure of introducing some of Ms. Akinsanya's legal team today. There is a slight change in the published lineup because I'm afraid Bea Rivers of Hackney Community Law Centre and Mike Spencer of Doughty Street Chambers are not able to join us today. So on our panel, we have Barrister Simon Cox of Doughty Street Chambers and Solicitor Berry Nwasu of Hackney Community Law Centre. And I'm going to hand over to Simon now, who's going to get us started, and he's got a presentation which is going to be shared on the screen.
Thank you very much, Nicole. That's a really clear explanation of a really complicated route to where we are now. So I want to just delve down into a little more detail about some of those points. Can I have the next slide, please, Rich? So the state of play at the moment is we've had two recent events after the Akinsanya judgment in January. We had a judgment in a case called Velaj, I'm going to talk a little bit about in the Court of Appeal on the 31st of May. And then we had the Home Office announce their review following the Akinsanya judgment in January and their new guidance. And so we now have pending, and I'll explain why, Ms. Akinsanya's judicial review of Appendix EU, that's in the High Court. And we have Mr. Velaj's application for permission to appeal from the Court of Appeal in the Supreme Court, which is 2 layers up from the High Court. Next slide, please. So, as Nicole has explained, the Court of Appeal in January decided two issues. They first of all decided what the rights are under EU law, and they decided that a carer, that the Zambrano right only exists where the carer has no domestic or other EU right to reside, or to work or to receive necessary social assistance. Now, that might be relevant to some people, and I'll come back to that. But the Court of Appeal decided that the right to reside under UK law wasn't extinguished by the grant of limited leave to remain. Next, please. So the Home Office has now took 6 months to work out what it wanted to do about that. And they've done two things. The good news is that they have dropped their policy that the possibility of getting leave to remain affects the Zambrano right to reside. So while they never wrote into the immigration rules this idea, in order to really gut the right that Sajid Javid decided that should be given to Zambrano holders, while the rules said that you didn't get it if you had leave to remain, their policy said that you didn't get it if you didn't have leave to remain, but you could get leave to remain, which in their eyes covered pretty much everybody else. So they've now accepted that that isn't right. So if you or your client is somebody who doesn't have leave to remain under Appendix FM or under any other provision, and didn't have it on the 31st of December 2020, but you were a Zambrano carer then, and you still are, then the Home Office should accept an application under Appendix EU by you. And I'm going to come back at the end of this presentation to time limits and so on for making that application. So in a what you might think is a flip around, if you did try and regularize your status and you did get leave to remain under Appendix FM or some other basis, the Home Office say you don't qualify under Appendix EU for Zambrano. But if you didn't try and regularize your status, or if you did and you were unsuccessful, in particular, like the most common cases are where people had criminal convictions. If you didn't get leave to remain, then you now do qualify for leave to remain on a Zambrano basis. But the main part of the review was that the Home Office decided they weren't going to change the rules at all. So while they changed their guidance to drop this extra hurdle for the group with no leave, they kept the rules in place for people who do have leave to remain. And so from the Home Office point of view, any person who has leave to remain as at the 31st of December 2020, or as at their date of application under Appendix EU, doesn't qualify as a person with a Zambrano right to reside under the Appendix EU definition, even though they may have that right to reside under Regulation 16 of the Immigration European Economic Area regulations. And while the Home Office say those regulations have been revoked, that's true, but it's not true for people who had the right to reside on the 31st of December 2020 and who made an application before the 30th of June 2021 under Appendix EU. So it's not clear how exactly the Home Office expects that to work out in those cases, but we can certainly see the policy direction that they're heading in. They've made one change for one group, but they haven't changed it for the largest group. Next slide, please. So, Akinsanya number 2. Why am I calling it number 2? Well, because Miss Akinsanya's case, when it came before the High Court last year in June, and when it came before the Court of Appeal, leading to the judgment in January, concerned what lawyers call a preliminary issue, so that concerned one set of arguments, and that was what's the scope of EU law right, and what's the scope of the Regulation 16.5 right. But what the court wasn't asked to decide at that stage was, is paragraph B unlawful for other reasons? Is it irrational? Is it unfair? Is it disproportionate? In particular, the argument goes that Ms. Akinsanya made last year in the judicial review. Is it irrational to treat people like her who did regularize their status less favorably than people who didn't? And bearing in mind that the impact of that, as Nicole has explained, falls almost entirely on single parents who are overwhelmingly women and women of colour. So those are the arguments that Ms. Akinsanya has permission to bring from the High Court, granted last year, and that she intends to take forwards in her High Court challenge going forward. So we can expect to get, unless the Home Office give her what she wants, we can expect to get a second judgment, which lawyers might call Akinsanya number 2, and that will deal with this second set of issues. Next slide, please. So let's just look back at some of the details of the Court of Appeal's judgment and what it might mean for some of you and some of your clients. So under Appendix EU says that any leave excludes a person from being a Zambrano carer except Appendix EU leave, right? But that wasn't the basis of the Court of Appeal's decision about EU law. What the Court of Appeal recognised in their decision was that it may be necessary for the person not only to have leave to remain, but also to have the right to work or the right to receive necessary social assistance. Without that means to support yourself, the person may face needing to leave the United Kingdom. So there's a question there about for people who have whose leave to remain for the relevant time was, for example, as a visitor or some other category which doesn't allow the right to work, whether paragraph B should lawfully be applied to them, or whether paragraph B is lawful in excluding those people. Miss Akinsanya can't raise that because she has leave to remain under Appendix FM. She has a right to work, and she has no condition stopping her from having recourse to public funds. But there may be other people who need to raise that issue in their own cases. Next slide, please. And a second issue that now arises is the Home Office new guidance expressly states that Zambrano carers must not have had leave to remain on the 31st of December 2020 or the date of application. But what happens when a Zambrano carer had already completed 5 years without having any leave to remain? If you look at Appendix EU, then the definition of a Zambrano person with a Zambrano right to reside states that they must be someone who, by the specified date, by the 31st of December 2020, was a person who is and was resident for a continuous qualifying period. Now, under the definition of the continuous qualifying period, the period of residence that qualifies does not need to continue at the date of application. Sorry, does need to continue at the date of application, but not if it's already been 5 years. In those cases, and Zambrano cases are all wrapped up in this, under the rules, only a supervening event disqualifies. So that would be living abroad for 5 years or going to prison. Getting leave to remain isn't a supervening event. And if you look at the structure of the rules and the language of the rules, there's an argument that this applies to the Zambrano carers. Certainly, if it doesn't apply to Zambrano carers, if 5 years doesn't count, then the inclusion of Zambrano carers in the various provisions that they're included in doesn't make a lot of sense, because it's hard to see how they could have been a supervening event in the case of Zambrano carers. Next slide, please. So people who've completed 5 years without leave to remain may have an argument that they qualify under the rules, even if they've then gone and got leave to remain before the 31st of December or before they apply. So the Court of Appeal's judgment in Velaj, Mr. Velaj was a joint carer with his wife, and the tribunal had decided that she wouldn't leave the UK if he was deported. He was facing deportation because he had a conviction, a lengthy prison sentence for importing drugs without a license. The Court of Appeal was looking at these words in the Immigration Economic Area Regulations. The British citizen would be unable to reside in the United Kingdom or in another EEA state if the person, or if there are two carers, both primary carers, left the UK for an indefinite period. And Mr. Velaj argued that that rule applies if they left. In other words, not whether or not they would leave. The Court of Appeal disagreed, and they ruled that those words, if the person left or if both primary carers left, meant that in order to qualify, the person had to show that they were going to, in fact, leave the United Kingdom, either by being deported by the Home Office, as might happen if neither carer had leave to remain, or because they would have to, because their circumstances were such that they would have to follow the other person abroad. Now, that hadn't been what the tribunal had accepted in Mr. Velaj's case, and so he lost, but he has applied for permission to appeal from the Supreme Court, a decision which will probably be given sometime later this year. Next slide, please. So, what happens in practice? Some people will have applications already pending under Appendix EU, other people won't. Now, the Home Office has announced that it will accept that there are reasonable grounds for lateness for Zambrano applications if they're made by the 25th of July 2022. So that's the deadline for people who don't currently have leave to remain. And I say that because under Appendix EU, a person who has leave to remain can wait and so long as their leave has not expired to make an application under Appendix EU. So for example, a person with leave to remain under Appendix FM, let's say until December of this year, doesn't have to make an application under Appendix EU now. They can wait until December, as long as they don't let their leave expire, and as long as they make their application before their leave expires. It'll be treated as in time by the Home Office under Appendix EU, which means that those people can wait and see what happens in the High Court in Miss Akinsany's case if they want to. Next slide, please. And that person can make a parallel application alongside an application for more leave under Appendix FM. So some of you or some of your clients may be people who've already got a pending application under Appendix FM because your leave was going to expire. You didn't want to become overstayers, so you made an application in time. Now, the normal rule is that if you made another application, for example, as let's just say as a work permit holder or as a student, that it would change to that new category. That doesn't apply to Appendix EU applications. They run on a totally separate track all on their own. So anybody can make an Appendix EU application without it affecting their other pending immigration applications. And anybody who's got a pending Appendix EU application can make an application under Appendix FM, and they run in parallel. Next slide, please. That doesn't mean that some people might not have hard choices. So the most obvious group who have a hard choice is people who wouldn't get settled status under Appendix EU, even if the arguments under Akinsanya succeed. Or they might be someone who doesn't have any leave to remain, hasn't ever had any leave to remain, but hasn't completed 5 years as a Zambrano carer. Now, if that person applies, they will probably be granted pre-settled status by the Home Office, and they'll be on pre-settled status until they've completed 5 years as a Zambrano carer. Now, under the benefits rules, that means they aren't eligible for claiming universal credit. They have the right to work, but they can't access mainstream benefits. In order to access mainstream benefits, that person would have to have Appendix FM leave. But if they apply for Appendix FM leave, then the Home Office will argue that they've lost their status as a person with Zambrano right to reside, because they now have leave to remain. But the person who is staying on the Zambrano route under Appendix EU will be entitled to settled status after 5 years as a Zambrano carer, while the person who's applying on the Appendix FM route will have to wait for 10 years with that leave, or some other lawful leave if they had it already, in order to qualify for indefinite leave to remain. So those people have hard choices. Next slide, please. So what's next? So first of all, the Home Office are due to decide Miss Akinsanya's application. Again, Miss Akinsanya is somebody who completed 5 years without having any leave to remain, and then got leave to remain before she applied under Appendix EU. And so she's arguing that the Home Office should grant her Appendix EU leave because she qualifies under Appendix EU. So we'll see what they make of that. If they refuse her application, then her intention is to go back to the High Court for, if you like, Akinsanya number 2, to pursue the arguments that she already got permission to raise with the High Court last year, for which the High Court has put on hold while these preliminary issues were decided. And at some point, we will get a ruling from the Supreme Court on Mr. Velaj's application for permission to appeal, which will either make that issue final or which will leave the door open to, in particular, joint primary carers qualifying for the Zambrano right to reside. So there are some questions in the Q&A which we'll try and deal with when we all get back together. Back over to you, Nicole.
Thanks very much, Simon. Brilliant. Now we're going to hand over to Berry from Hackney Community Law Centre, who's going to talk us through some practical issues and tips from a practitioner's point of view.
Thank you, Nicole. Thanks, Simon. So Simon has gone through the Akinsonia case and where we are with the new policy. From our point of view, we have not received or seen a refusal from those who made the EUSS applications under Zambrano. I've only spoken to one person who had a decision, but I didn't get to see the decision. So we're not sure. I mean, we believe the Home Office is making the decisions, but we're not sure on what basis applications are being refused. As in, if you get someone like Mr. Kinsanya, for instance, who was a Zambrano carer for 5 years before she even applied for leave to remain, if they're being refused, we haven't yet seen the reasons for refusal. Or if they're being granted, again, we haven't seen the decisions yet. So unfortunately, on that aspect, we're a bit the facts are a bit scarce, to put it that way. What we are advising our clients and callers is, if anyone still thinks there's a chance they qualify under the Zambrano EU SS application, they should still make the application because it is still, I mean, Akinsonia is still in the courts. We know what the policy is right now. As long as we can make arguments based on the policy now, we should be fine, with the hope of maybe adding other information when the cases that are in court, the Velage and the Akinsonia cases, are dealt with. Because then at least they will have an application pending. Where clients have leave to remain under, especially Appendix FM, we are erring on the side of caution and advising them to renew those applications. We're looking, basically one is just so they have some secured form of leave, because if they let the Appendix FM leave lapse, they may fall in the benefit trap. But most importantly, if at some point they get to the 10-year stretch of having leave, they will not be able to, may not be able to apply for indefinite leave because they've had this break in grants. And to be fair, we really, whilst we think, well, we have the cases ongoing with the Home Office and the way things go, we cannot tell clients definitely the Zambrano cases will succeed or not. And we cannot tell them, I mean, if we all look at the progress, I will use the word progress, in immigration rules, a breach or a break in grant of leave could have serious implications somewhere down the line, depending on when they decide to change the immigration rules again or add policies that, might adversely affect clients. So on that side, I am telling everybody, make sure you have leave to remain. If you need to put in an extension, put in the extension and just hang on, because we can't, guarantee what will happen in that respect. We are urging, anybody who has received a decision to contact me on our advice line. We could review with you if need be to see what arguments can be made, and depending on Simon's availability, he hasn't said anything yet, I'm just throwing him in there, we may take his advice as well. Like Simon said, in the event that Akinsonia is granted indefinite leave to remain because she had, she was a Zambrano carer for 5 years before she applied for leave to the Appendix FM leave to remain, then it possibly could be don't have a challenge. So we could look at challenging other aspects of the new policy, especially in cases where, there are arguments to be made. Other than that, the Zambrano applications are still paper-based, so you still have to call the Home Office telephone number, or you could send an email to formz, it's FORMZ at homeoffice.co.uk to request a form. You need to provide full name, date of birth, nationality, email address, and the forms will be sent within 5 working days. If anyone needs the forms posted to them, then they need to call the number. I'll give it to you and probably put it in the chat. Is 0300 1237379, and you need to speak to someone. So you give them your address, and the forms will be sent to you by post. So if anyone who needs to put in the applications. With regards to challenging the decisions, there's still 2 ways of doing it, either by admin review or by lodging an appeal. Again, it will depend on the decision and the merits of the claim, which avenue we take. The admin review needs to be in within 28 days, whereas the appeal is 14 days standard. The appeal to the first tier tribunal. So again, it will really be fact-based and merits-based to advise a client on the best way forward. I believe that's all for me. Nicole?
Thank you very much, Berry. Right, okay, so the final section of our session this afternoon is going to be questions and discussion amongst panel members. So I can see that we've got lots of questions. Before I get to them, I'm conscious that there might be some individuals in our audience today who might themselves have pending EU settlement scheme applications. I just want to sort of manage expectations that we're in a training seminar here. We're not in an advice context. So our panelists are not going to be giving individual advice in response to any questions about people's cases. We will have a look at those questions and see if we can make any points of general application. But in terms of advice, unfortunately, this isn't the space for that, but we can certainly signpost to advice agencies. Right, let's start off with the first question that was put, and that was from Natalie from Cardinal Hume Centre, who's asking, do you think that there will be any remedy or challenge for parents who applied to the EU settlement scheme as a Zambrano carer who had no other leave prior to the specified date, which is the 31st of December 2020, and then their application was refused on the basis of the policy that you couldn't apply if there was potential to have limited leave under a different route? So yes, Simon, I think you touched on this a little bit in your presentation, but do you want to come to that point first?
Sure, Nicole. So I think that so there'll be some people who applied, got a negative decision under Appendix EU, and then in response to being told by the Home Office that the proper thing for you to do is to apply for leave to remain under Appendix F, they did what they were told. If those people appealed that decision, and that appeal is still outstanding, then they can make the argument that the Appendix EU never excluded them and that the original decision was wrong, and that therefore they should be granted leave to remain. I think if they didn't appeal, then they may want to consider putting in a late appeal. If they apply before the 30th of January 2020, is that right, don't I? Then they won't have a right of appeal. Thank you. And judicial review will be the remedy, and it may be possible to make an application for judicial review. I think the crucial issue in all those cases, though, will be whether the Home Office can properly and lawfully refuse to grant the leave under Appendix EU because they told the applicant about their unlawful policy, and then the applicant applied. And I think that those cases are going to need an individual consideration from a lawyer. I don't think it's something that I can express a view about here. And I think, but I certainly think that there will be. It's not clear that that's lawful. That the Home Office, if the Home Office does that, but it might be that a late appeal is an effective remedy for that. But I can't say whether or not that would be the right thing for any individual to do.
Thanks very much, Simon. Let's go to the next question from Masari. This question appears to be about their own personal circumstances, so we'll certainly have a look at it and see if we can draw out any issues of general application there. So the question is that me and my family have got Zambrano since 2018 with a residence card. So it sounds like there's a derivative residence card as a Zambrano carer for 5 years. But because it didn't allow access to benefits, talk to MP and the Home Office when we're, of course, as they were doing at that time, advising everyone to go for limited leave under the family route, which was applied for. And I'm guessing that's a typo in 2019 and was accepted. But then obviously the EU settlement scheme arrived, and as everyone else, I'm sure you considered, and you did, you and your family applied, and you were refused because you had limited leave. After that, you talked to the Citizens Advice Bureau, who advised you that you could reapply, which you did in June 2019, and you relied on the Akinsanya case. And you've also applied to renew your leave. Well done, to make sure that was continuous. And yesterday you received an email from the Home Office that they've granted your leave to remain. Now I'm guessing that that grant of leave to remain was on the Appendix FM route. So what you're saying there is that you had continuous limited leave under Appendix FM from 2019 until now. And you have a pending EU settlement scheme application, I think. So that's the scenario that we, Simon touched on, and we can go back. So people who have, got limited leave over that important date of the 31st of December 2020 and had it since then and have a pending EU settlement scheme application. What's the impact of the new policy on them, Simon or Barry?
So, I think a person in the situation that Masari describes is in the same situation as that of Miss Akinsanya, except that they didn't complete 5 years without leave before they were granted leave under Appendix FM. So I think for those people, that their route to getting leave under Appendix EU will depend upon the High Court upholding Miss Akinsanya's arguments that the exclusion of people with leave to remain is unlawful because it's not logical or because it's not fair. So I think for those people, they should consider whether or not they need to make an application to protect their position. As I've explained, people who have limited leave to remain don't need to make an application until that leave is about to expire, but they must do it before it expires. I think the other advice then is to wait and see what ruling the High Court gives in the Akinsanya case.
Thanks, Simon. And I suppose in those cases, what you've got, what our understanding is, Masari, is that you and others will have a pending application. You've got your limited leave. It's spanning over that period, ending, on the 31st of December 2020 and since. You've got a pending EU settlement scheme application under the terms of the current Home Office rules and policy. They will refuse you, most likely, as other people in that situation. And the question is, unless, maybe we'll get a delay in decision making, we don't know. If decisions start to come applying the rule and the policy as it's currently written, what do you do? Well, as we've alluded to, there's rights to challenge, depending on when the application was made. Masari, I think you mentioned some dates there, but the right of appeal to a tribunal only applies, as Simon said, if an application was made by the end of, on or after the end of January 2020. So otherwise, administrative review is your only option. Now, the interesting thing to think about with administrative review and appeals, if you're thinking about which route to go down, is what's happening in practice out there. And administrative reviews at the moment are taking an incredibly long period of time. So one thing that I have talked, for example, to some of our service users about on our advice line is using administrative review strategically to keep your application pending whilst you wait and see what happens in Akinsanya number 2. So administrative review, of course, is a cost of £80 that cannot be waived. You can submit that within 28 days of a refusal. At the moment, the Home Office is taking an extraordinarily long time to decide administrative reviews, probably about 6 to 12 months, during which time, of course, there will be ultimately, one would hope, a High Court decision. So that's one issue that you could be playing around in your mind in order to get a bit more time. And of course, remember, at the end of administrative review procedures, you also have a right of appeal. So if you have, well, you won't, depending on, if you didn't submit your application after the 31st of January, then you won't have a right of appeal. But of course, you can still pursue judicial review at the end of a negative administrative review. Simon, you're peering through your glasses as though you don't agree with me. Is there anything you disagree?
No, I'm just trying to work out what I might say about some of these really difficult questions in the chat. I'm sorry.
Yeah,
sorry.
No, that's all right. That's all right. I was just double checking because a lot of these things are unfortunately really difficult sort of strategy decisions that you want to make on the individual circumstances of a case. Right, Masari, you've got another one posted there, but I think we have addressed that too. Bethan is right. Bethan from Praxis is asking, for those who completed 5 years leave to remain before 31st of December 2020, would their child still need to be under 18 as of the 31st of December 2020? Do you mean 5 years, Zambrano?
I think she means 5 years without leave to remain.
Yeah, okay.
I don't know the answer to that, but it's quite big. I see that.
Barry?
Probably don't want to talk about it.
Probably just using logic, if we can use that, because the EU adult age is 21, isn't it? Can we raise that argument to say when they get over 21?
Just step right outside the bounds of this seminar.
I know. That's what I'm just like.
My tiny little head will explode if we try and do that.
We'll go to Bethan's next question. Those who can make an application later than the 25th of July 2020 because they have existing leave to remain, does that leave need to have started before the end of the grace period, that is before 30th of June 2021?
Well, I'm going to ask Nicole, have you seen any sign from the Home Office that they think that's the position?
I haven't seen any indicators on these things, Bethan. Yeah, I think it's going to be one of those things where people will have to try and see whether the Home Office will accept the principle based on a variation of leave. My instinct was that, you know, they weren't going to go for the variation argument.
But on a literal, but Bethan, if you look at the definition of relevant dates, it paragraph, sorry, not relevant dates. So I have required dates. I'm so sorry. So if you look at the definition of required date, if you look at paragraph Roman, sorry, if I can be practical, if you look at paragraph V, 5, Roman 5, then it says, in the case of an applicant who has limited leave to enter or remain granted under another part of these rules, which has not lapsed or been cancelled, curtailed, or invalidated, and the date of expiry of that leave is on or after 1st of July 2021, the Secretary of State will deem to be which, notwithstanding blah blah, the Secretary of State will deem to be reasonable grounds for the person's failure to meet the deadline. The date of application is before the date of expiry of that leave. So, you know, I think that Appendix EU doesn't have any limitation. And why would it? What the Home Office is saying is if you're here lawfully anyway, fine, you don't need to apply. But they might change it, of course, or they might think it means something else. So it may be that for people whose leave was granted after that date, it's unwise. But on the other hand, that's what it says at the moment. Nicole, can I just answer the question about entry clearance?
Yes, we're going to go to that one now. So Simon's going to talk to us about issues around entry clearance applications as a Zambrano carer.
So this is when you're not in the country, when the Zambrano carer isn't in the country, and therefore presumably the British citizen child is outside. the country. Until 31st of December, there was a possibility to get a family permit on that basis as a Zambrano carer. If you could show that were you in the UK, that the British citizen child would need you to be there. So people who did apply for that permit before the 31st of December 2020 should be entitled to a decision on it. And if they get the permit, then under Appendix EU family permit, they should qualify for leave to remain under Appendix EU. But people who didn't apply before the 31st of December 2020, but were Zambrano carers then outside the UK, are going to have to talk to a lawyer or a specialist about whether or not there's anything that can be done in their cases, I'm afraid. Thanks,
Simon. I'm going to skip over some questions for relevance reasons, and I'm going to come to one from Lenovo, a British child born 1 or 2 years ago, or maybe half a year ago, but the mother has been in the UK over 5 years. Can she apply under the Zambrano route under the EU settlement scheme? I mean, the issue around being, the EU settlement scheme being engaged is, do you have a British child who existed by the 31st of December 2020? If your British child didn't exist by the 31st of December 2020, then you weren't their primary carer by that point. That is an absolute cut-off date for the EU settlement scheme. So if you're looking, obviously it's easy if your child was automatically born British. Some issues that we've come across in our services that people need to remember: if you've registered your child as British, they're not British from birth, they're British from the date of their registration certificate. So if you're looking for advice on that issue, make sure you know exactly the date that your child became a British citizen. But unfortunately, if you don't have a British child by the 31st of December 20, then you're out of the scheme entirely, and you're exclusively relying on the FM route. Okay, we have a couple of people talking about having received refusals, Catherine and Bethan. No questions arising from those, I can see, but really interested to if you wanted to speak to us privately about that. That's great. Okay, there's a question on the COAs, more of a practical point. Someone who's applied before the deadline still hasn't received a certificate of application. What action can you take? There are very known problems with the issuing of certificates of application. The action that you take very much depends on the reason for the delay. So as always, unfortunately, lawyers would say seek individual advice to understand the circumstances. So in order to get a certificate of application, you're dealing with multiple issues. First, did you complete the right application form? The Home Office will be checking that. Secondly, have you produced satisfactory evidence of your identity and nationality? And thirdly, have you enrolled your biometrics? If you've used the right form, the Home Office has got it, and the Home Office would have sent out that acknowledgement letter, which they were doing. So if you got the acknowledgement letter saying we've got your application, but this isn't a certificate of application yet, then you know they've got it. You know whether or not you've given them valid identity. If you haven't sent them a valid passport or a valid biometric residence card, then potentially you're facing the issue of having no ID and the Home Office delaying because they're refusing to validate on that basis. Get advice on that. If you've enrolled your biometrics and you've got no ID issues and you still don't have a certificate of application, then there's something wrong. I'd certainly try and get support from lots of the advice lines that are out there, and advice lines can call the Home Office with you and make inquiries around delays. So yeah, unfortunately I can't say much more than that, other than there are known chronic issues. You can report to the Independent Monitoring Authority, the likes of the 3 million, who sort of gather evidence of breaches of the withdrawal agreement, but that doesn't necessarily resolve those individual issues. Okay, I'm going to skip forward to Maria Popova. I've got a number of clients who've made an EU settlement scheme Zambrano application and had leave at the relevant dates and have not completed 5 years as primary carers prior to having leave. Would you be able to confirm if we should be appealing these decisions? I think we sort of touched on those issues before. Does anyone want to add anything?
No, sorry.
I mean, I think that where clients want to benefit from a positive judgment in Akinsanya number 2, if Akinsanya number 2 wins, it may not win. then it would be a good idea to appeal if they're in the same position as Miss Akinsanya, arguing that or they can appeal, arguing that the rules are not valid, that paragraph B is not valid because it's made unlawfully. That's the same argument that we've made in several appeals, and so far the tribunal has generally accepted that it has jurisdiction to look at that.
Thank you. Right, looks like another individual's question. Let's see if there's anything that we can pick out here. On a 10-year parent route, daughter is 3 years old. Partner is the non-biological father of my daughter. Staying and looking after her since she's 6 months, but we're not married and he's not adopted her because he's an overstayer. Is he able to apply for Zambrano now? I have already applied Zambrano based on the new policy, but I don't think my application would be successful. So what we've got here is one parent who has FM leave, presumably as the parent of a British child. The other partner who has no leave is not the biological parent of the child. And the question is, can the non-biological parent, who is a joint carer of a British child, apply under the Zambrano application, and what's their chances of success?
Well, I mean, I think unfortunately, this is my view, and I'm happy to be corrected. The Zambrano right to reside is individual to the Zambrano carer. It doesn't confer any rights on family members. If I've understood the correct question correctly.
Yeah, I didn't even think that he might not qualify. If you look at, if he were to go home, would the child be forced to go with him or stay with mom? I guess that's the way I looked at it.
The text of mine is so. Which one are we talking about now? Because I think my text to that has just disappeared. I'm so sorry.
That is because I said it was being answered live.
The answered ones. Yes.
The partner who is not the dad.
Yeah.
And the mom
PJ.
has lived.
Oh, my apologies. Sorry. Yes. So there have been cases in which the tribunal has accepted. So there are a couple of issues there. One is, can you be a Zambrano carer without being a biological parent? And certainly the answer is yes. There have been people who've been accepted as being a Zambrano carer without being the biological parent. I think in terms of, did you, right, yes. But in terms of whether or not they were the sole carer, or whether you could show that you would need to leave the UK if they were removed, that's going to depend on your individual facts. And I think that's going to be the challenge there, is that in the joint carer cases, what the Home Office will often say is, they don't need both of you. They need one of you, and the other person can leave the country. And so I think that's generally the challenge in joint carer cases where one carer has leave to remain. I'm sorry, Nicole, I was confused about another question.
Thanks, Simon. I'm going to jump to a question from Chloe that I thought looked interesting. If someone is granted pre-settled status as a Zambrano carer and they have 2.5, presumably, so they already have 2.5 years leave to remain under Appendix FM with recourse to public funds, then they're granted pre-settled status as a Zambrano carer. Does the pre-settled status trump the 2.5 years leave given under Appendix FM? My answer to that is yes. It's a variation of leave. Simon, any thoughts?
I think it depends what the letter says. I think the Home Office certainly has power to say we're going to give you leave on 2 bases. No reason why they can't give you leave on 2 bases. So I think it all depends on what the letters say. And I can't say couldn't say without saying.
The letters are standard letters. The letters will say, a pre-settled status grant will say something as basic as, we're delighted to confirm that you've been granted pre-settled status under the EU settlement scheme granted under paragraph EU3 of Appendix EU. This takes effect on this date, and it tells you the expiry date. It will be a standard template letter. It doesn't say, it won't say anything about your existing leave remaining intact. So on that basis, and also I'm not sure I've seen any other precedent.
I mean, the tribunal that's going to be looking at it, if it gets to a tribunal, is the first tier tribunal in social entitlement chamber, because presumably your concern here, Chloe, is about access to benefits rather than anything else. So in those situations, I think it will depend upon what the DWP and what the appeal tribunal there thinks of that letter. It seems to me that where you've already got leave to remain and it doesn't have a condition attached, sorry, it has no condition attached to, for recourse to public funds, and then you're granted leave on a second basis. I think it'll be open to the tribunal to decide, depending on the evidence, that the Home Office have granted you leave on two bases. We'll have to see. I think it will be up to the tribunal to decide. I don't think it's clear, to be honest. As Nicole says, this doesn't say this ends any previous leave you had, or this changes or varies your leave to remain. One of the challenges we face as lawyers in this field is that the Home Office ignores what the Immigration Act actually says and just uses some different words, which may be more customer friendly, but they leave it legally unclear as to what's actually happened to people with their leave to remain. Can I just flag up two very quick things in that I've seen in the questions? If you apply for administrative review of your decision in time, you don't have to bring an appeal until 14 days after you get the administrative review decision, but there isn't a fee waiver for the administrative review. So you will have to pay the fee waiver for the administrative review. And if Ms. Akinsanya's judicial review goes ahead, then it's not going to be about people who had 5 years first. It's going to be about larger issues than that in practice. Who had 5 years as a Zambrano carer before they got leave, in the answer to one of the questions that came up there. It's going to be about the much larger issues the court, I don't think, is likely to limit it to that small class of people.
Okay, we have pretty much come to the end. I know there are loads of questions still outstanding, and I'm sorry that we can't get to them all. I think in terms of getting advice, there's lots of people in this audience who are probably individuals wanting or are making applications. Hopefully you already have access to immigration advisors. If you don't, there's lots of places that you could start to try and identify services. The Home Office, for example, has funded a network across the country of organisations to advise on the EU settlement scheme. So you can sort of put into Google EU settlement scheme community organisations, and then you get a list of those. You'll need to make sure that you contact organisations that are registered with the OIC at level 2 or above in order to access advice. Barry at Hackney Community Law Centre has made reference to an advice line that they operate. Certainly Rights of Women operates an advice line for women only to receive advice. We're also open, and you can find details on our website. And it's in addition to those organisations that are funded by the Home Office, I imagine the law centres across the country will be in a position to provide advice, and then other specialist charities, some of whom are in this room, such as Praxis in London. So do try and get updated, individualised legal advice from the practitioners in the room. Of course, the conversation continues. If any of you want to sort of discuss and strategize around issues on refusals, feel free to get in touch with those of us in the room. We're not promising we'll be able to advise and support, but feel free to see if we can sort of input anything into the approach. And I imagine that we will keep you all updated on developments. So Hackney Community Law Centre are great about keeping their website up to date. So do follow their Twitter feed, but also on the news link on the Hackney Law Centre website, they will put updates there as and when issues develop in Akinsanya number 2. And if at any point we feel that there's merit for a further seminar on this subject, we will of course convene one, and hopefully Doughty Street will host us again. That's my final word. Do any of the panelists want to offer a final word?
Thank you very much, Nicole, for so clearly and firmly steering us in the right direction. it's really complicated, folks, and I'm sorry that we're not in a position and that our legal aid system isn't up to advising you. And I'm just sorry that this is also complicated. Immigration law rights shouldn't be this complicated. And you shouldn't need lawyers, shouldn't need to have a seminar like this. But we do the best to try and cut through the complexity. And I'm sorry that we haven't been able to answer all the questions today.
Thanks, Simon. Thanks, Barry. And thanks everyone for joining us and contributing in the chat and questions as well. That's been fantastic. All right, take care, everyone. Have a wonderful weekend, and I hope you can enjoy the beautiful heat wave that is about to come. All right, take care.